printed on 8/14 of 2013. Is that what the return of service is from the Sheriff's Department? Yes. July 15th of 2013, Sheriff's return of service. Yeah. So, this reissuance of the temporary order for protection notice of hearing, Superior to Washington. Budnick petitioner versus Budnick respondent. The order of protection issued on July 6th of 2012, hereby extended through the new court hearing date on the matter, August 30th of 2013. At 2 o'clock at Clallam County Superior Court. May serve respondent by mail and publication instead of mail or, yes. And the modified protection order entered on October 16th of 2012. What? So the return of service was not to me, no. It was a return of service from the Sequim Gazette, yeah. And then you reissued the temporary protection order on July 19th, yes. But you could have issued it for 24 days. So why did you reissue it? And then there was a proof of mailing declaration, return of service, undeliverable mail. And then you had a motion hearing where you put it in publication, yes. You have proof of mailing, yes. But you have nothing in the actual court record about the publication. Isn't there some sort of entry that's necessary to prove court-ordered publication? There is. Well, just think about all the people that don't know about you putting it in the newspaper. Pooch. I thought everybody wanted a copy of this. That's why. Mail and publication. No, it's mail or publication. And the modified protection order entered on October 16th of 2012? Yes. This modified where Greg Miller, where you decided to modify it, but I didn't get a copy of any of the documentation that alleged that I was some crazy berserk individual. You know, I want you to remove that protection order. You're intentionally interfering with my right to sue you. And I made sure that the whole world could have a copy of all of this if they wanted it. Now, I'd still like to know, okay, who was not served on June 22nd, and then what person was not served on July 23rd, and then how can you have a protection order, permanent protection order hearing? Yes, 50 days after you issue the temporary protection order. And then how can you issue it without the signature of the petitioner? Could you tell me that? How could you have a court hearing without having proof of service? You know, I think there was something. Oh, what's this? A motion to dismiss. Respectfully, Jack Range, gatekeeping should determine threshold of alleged applicable would support the crime. State versus Millen order is not applicable to the charged crime if it is not issued by a competent court, is not statutorily sufficient, or is vague or inadequate on this case. Otherwise, not support a conviction of violating or issue a superior court protection. There must be proof of service on the respondent. Well, there's proof of not serving the respondent. There's proof of serving somebody else. Hooch. There's proof of attempting to serve somebody else. Hooch. There's no proof that the petitioner motioned the court. Hooch. And there's no signature of the petitioner. Now, here, none of the boxes representing methods of proving service in the 2015 order are checked. In fact, the docket notes show the Clallam County Sheriff's Office did not serve Mr. Budnick at all. You didn't serve me. Oh! Is there some reason why you won't remove it? You don't want me to sue you? I'm going to need to look at those rules of judicial conduct again. You know, sometimes when you expose corruption, various felonies, and the violate or attempt to violate the rules of professional conduct. knowingly assist or induce another to do so, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Isn't it deceitful to issue court order? Engage in conduct that is prejudicial to the administration of justice. Nobody state or imply an ability to influence improperly a government agency or official, or to achieve results by means that violate the rules of professional conduct or other law, or knowingly assist a judge or judicial officer in conduct that is in violation of applicable code of judicial conduct or other law. Now, how many attorneys have been assisting judge or judicial officers, county court clerks, in contact that is in violation of applicable code of judicial conduct? Now, when I start going, oh, 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 uh, the world's largest ethics violation. Um, civil rights, victims' rights, federal legislation rights, humanitarian rights, civil liberties, children's rights, and business rights. Reporting professional misconduct. This is 8.3. A lawyer who knows, that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, shall inform the appropriate professional authority, except as otherwise provided in these rules or by law. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority. Now, Judge Landis, how many attorneys have informed the appropriate authority? Well, you're trying me from. Um, I'm going to have to know of every attorney that knows about this. I'm sitting in the study room because nobody will enforce my rights. Now, I think that you can be legally liable as a lawyer for refusing to inform the appropriate authority about the conduct of any judge that doesn't enforce the civil rights of American citizens. So why don't we go through and just look at there. Video evidence, numerous accounts, the subversive form of government that advocates. I told you I want a phone call from my sons. I sent you an email that I want you to remove the protection order. And I will sue every attorney of this nation that has any of violating the professional rules of conduct of any judge, because nobody would